everyone, Joe Killinger with theRRD. Today I wanted to talk to you about ADA compliance, and I've reached out to a friend of mine, Carla, that's a real estate attorney for a large developer in Los Angeles, so I'll be anxious to hear what she has to say about it. Thank you for coming in today, Carla. I guess let's touch on property managers, landlords, and real estate agents and how ADA compliance affects each one of those. So I guess let's start with landlords.
I think that there's a misconception that landlords, if they build something into their lease, that it alleviates them of any kind of culpability as far as ADA compliance. And that's a big misconception. So landlords do need to be careful because they definitely are liable for any kind of ADA compliance on their property. And not only that, even if you build in a component to your lease that limits the culpability and passes some of it on to the tenant, let's say an indemnification provision, that is only contractually between the parties, between the landlord and the tenant. It is definitely not going to alleviate the landlord as far as any ADA compliance in and of itself. So you do want to make sure that you have something built into your lease as a landlord or an agent or a property owner. But just remember that you are still going to be compliant, and especially, let's say in a commercial property, it doesn't alleviate a landlord at all for the common areas. So a landlord has full responsibility for ADA compliance in the common area. So probably the best thing to do is make sure that you build things into your lease that sort of share some of that responsibility. You are going to want an indemnification provision from your tenant that usually allows you as a landlord to choose defense counsel if you're sued for non-compliance.
So you can put onto the tenant to remediate the problem, correct?
Yes.
Okay, so they can remediate it, but they will not be, if they moved into a property that had an existing problem, they won't be held responsible. The landlord still will, but they can be held responsible for remediating.
Correct, but just remember again that that's between the parties, between the landlord and the tenant, and whatever contractually they want to do. But as far as the law goes and federal law goes, the responsibility is on the landlord. So you can build in as a landlord or a property manager what you'd like your tenant to take care of and be responsible for financially. But as far as the law goes, it is going to be passed on to the landlord if there's any kind of non-compliance issue and resultant lawsuit.
Do you know about how much the penalties are for ADA? Out of the blue, probably you don't, but I just thought I'd throw it out there.
Thanks for
Yeah,
that, Joe.
you bet.
I appreciate that.
Yeah, throw it under the bus a little bit.
Let me hang on.
So I'm guessing that's
I have
a
it
no.
right here.
Yeah, that's a no.
It's percentage-wise. It's different by state, and they've
Okay.
changed some of the laws. I do know what it is for California, and there is sort of like a flat. You get a discount bargain rate in California, but you would want to check your state. And first of all, you want to make sure you're in compliance, but it goes by state, so
Okay.
it's a different.
Okay. So property management company, can they be held liable for ADA compliance?
Well, not technically. It's the same kind of thing. If a property manager is negotiating the lease, you're going to want to make sure that there are key things built into your lease that limit the exposure of the landlord as best you can, because again, the overall umbrella does go back to the landlord.
Right.
So, but you do want to sort of built in some things where the parties work it out together prior to entering into the lease. Shared expenses, shared defense costs, or actually even pushing the defense cost onto the tenants. Certainly a landlord or property manager, when they're walking the property and doing inspections, they're going to want to make sure to be up to date on whatever the current laws are in that state. Do property walks, make sure a tenant's in compliant. Things do change all the time, and unfortunately, not a lot of it gets passed on to landlords and property managers, but there will be people, unfortunately, that take advantage of any of the new laws, and there's a lot of serial plaintiffs that will go onto a property and take note of any kind of accessibility issue and just file lawsuits against every property.
Right.
Perhaps somebody who is disabled has not even been to the property, but there are attorneys who will find clients and then will go out and get these people to jump on the bandwagon and file these lawsuits. I mean, I've done a few of them for retail developers, so.
Okay. I kind of lost my train of thought here because I had so many questions as you were talking, but
You know me, I don't shut up. So.
Yeah, well, long-winded
Gotta
attorney.
jump right in.
Long-winded attorney, they're not that common, I guess. Okay, so the property management company really cannot be held liable for for the ADA compliance. However, it should be their responsibility to go out and make sure the property is ADA compliant. If it's not, get it brought up to code.
Correct.
As quickly as possible.
And especially for California, that's what I know, and I don't really know the other states. Once you do remediate any kind of ADA issue, you should get an inspector to come in. There's something in California called a CASP inspection or inspector.
Okay.
And that's specifically what they do. And once you pass that inspection, you can even put it in your storefront that it's a compliant property.
Right.
And that'll also alleviate some of these sort of serial lawsuits if they see that.
Right.
But then I've done it for property owners and landlords, and then if you have any of these issues come up, you give them the CASP certificate,
Right.
and it sort of immediately takes away some of these problems. So.
Okay. Now, lastly, how about real estate agents? What is their responsibility to disclose the ADA compliance?
Well, again, that was something, if an agent's negotiating the lease, you're going to want to make sure that these landlord-friendly provisions are built into your lease. It's the same kind of thing as the landlord itself when negotiating a lease. That culpability is split between the landlord-tenant. But again, that's just between the two parties. It doesn't alleviate you from any kind of federal laws or responsibility as a landlord or a property owner. So for the agent who's negotiating the lease, you're going to want to make sure there's that indemnity provision that protects the landlord. Maybe you can work out some kind of agreement as far as the common areas go, because the way the law stands now, the landlord is responsible for all the common areas.
Right.
So you may want to have some kind of shared expense with the tenant if it's in an area that they utilize or something that they may have caused. That aside, if it's not a lawsuit related, let's say somebody comes in, it's like this ramp isn't to code. That might not be a lawsuit. It may be somebody that just filed a claim. That there's some kind of shared expense, or the landlord is able to pass it off to the tenant.
Yeah. And then, or if you're in escrow, you're an agent and you're in escrow, and you've got a deal that's getting ready to close, and you find that there's a pretty good amount of work, you can go out as the agent and maybe get a reduction in price, or get a credit back through escrow.
Right,
for your client.
Or have them maybe build in the cost of the CASP inspection.
Right.
To make sure everything's compliant before you actually close escrow. So.
Yeah, exactly. So, well, I hope that clarifies a lot of this for you. If you ever have any questions, don't hesitate to reach out. info@theRRD.com, and we'll try to get everything answered for you. Or if you want to talk to Carla about something regarding this ADA compliance, please reach out to me and we will put you in touch with her. So thank you very much.